Hello, I'm Akira Arroyo, Director of the Neighborhood Entrepreneurial Law Project at the City Bar Justice Center. Thank you for joining today's webinar on small business contract issues arising under COVID-19. The Neighborhood Entrepreneurial Law Project, or NELP as it is more commonly referred to, has been providing legal assistance to low to moderate income micro-entrepreneurs hoping to start businesses in New York City. For over nearly 20 years, we've worked to assist over 15,000 entrepreneurs and small businesses, and have worked with volunteer attorneys from over 100 different law firms and corporate in-house legal departments to deliver legal services to individuals who saw entrepreneurship as a means of creating economic stability for their households and communities. Typically, we assist with issues such as entity formation, commercial lease reviews, contract drafting and reviewing, and intellectual property right protection. Today, with the COVID-19 pandemic, we, like many small businesses, have had to also pivot and change our business model and focus. Next slide. Previously, the bulk of our programming took place out in the community in places such as libraries and solution centers. And now, as a result of the outbreak, we have moved towards an online and remote model of delivering pro bono legal services, which has resulted in the creation of the City Bar Justice Center's COVID-19 Small Business Legal Clinic. Through our remote legal clinic, business owners can sign up on our website, citybarjusticecenter.org, for a 45-minute limited scope legal consultation with pro bono attorneys who are trained to assist business owners to better understand and act upon the federal government's stimulus package, as well as other opportunities available through federal, state, and local programs. Small businesses can also ask questions about other issues, such as contracts and force majeure clauses, which we'll learn more about in today's program, employment law matters, commercial leasing issues, and insurance matters. Our focus as present has shifted to working with already established businesses to try and help them remain in business and get through these difficult times. To that end, in addition to our remote legal clinic, we are hosting presentations like today's geared towards addressing issues that are current and commonly impacting small businesses today. Before we begin today's program, I'd like to thank the Brooklyn Small Business Development Center for co-sponsoring this event with us and for being a constant source of information and support for New York City's small businesses. I also want to thank the law firm of Cleary Gottlieb for partnering with NELP and the City Bar Justice Center on our COVID-19 small business initiative from the very start, and for putting together today's webinar on small business contract issues arising under COVID-19. In an effort to ensure that small business owners are aware of the full scope of their options under current circumstances, the attorneys from Cleary Gottlieb will provide a brief overview of contract basics, including breach, remedies, and limitation on damages, an examination of key contractual provisions and concepts, and practical guidance to small business owners on how to protect your rights and focus on practical results in negotiations with counterparties. Just a few more housekeeping issues to address before we begin the program. The presentation is being recorded and we will circulate a link to all participants with the recording and slides in the coming days. We will also try to reserve a few minutes towards the end of the presentation so that the speakers can address questions from the audience. Therefore, please type your questions into the Q&A box at the bottom of the screen during the presentation, and towards the end, the speakers will try to address as many of those questions as possible. And with that, I am pleased to welcome Shirley Lowe, Martha Vega Gonzalez, Namat Lawal, and Laura Doherty from Cleary Gottlieb. Now I'll turn it over to the Cleary team. Thank you.
Thanks very much for that introduction, Akira, and thanks as always for all of your help to small businesses as part of the Neighborhood Entrepreneur Legal Project. So just wanted to give a quick introduction of the team that'll be going through this presentation. I'm Shirley Lowe. I'm a counsel in the finance group at Cleary Gottlieb. I think the other members of our team will also introduce themselves.
Hi, I'm Martha Vega Gonzalez. I'm an associate in the litigation practice group at Cleary Gottlieb.
Hi, I'm Namat Lawal. I'm an associate in the mergers and acquisitions practice group at Cleary Gottlieb.
We might be having some technical difficulties as we're going through this, but we also have Laura Doherty on the team as well. Next slide, please. So we just wanted to start with a quick disclaimer that, all the information in these slides are current as of today, May 21st, 2020. It is a summary and it's not going to be comprehensive. This webinar, of course, isn't a substitute for, and you shouldn't rely on this on legal or professional advice. We do recommend that you consult with professional legal, financial, and tax advisors for guidance on, your particular cases. And then nothing in this presentation will create a attorney-client relationship with Cleary Gottlieb. Next slide, please. So we'll first start with an introduction about the goal of this presentation and just the points we're going to try to cover, and then we'll kind of dig into all these contract issues that folks are encountering. So this, I'm sure, is an unprecedented time for everyone who is participating in this seminar. The COVID-19 pandemic has definitely presented a lot of unprecedented challenges, and the response by the government for health concerns has definitely placed also a strain on the economy, and I think a particular strain on small businesses. And we are seeing small businesses, or self included, I'm sure, that are running into a lot of problems with their contracts because either you or the other side of the contract can no longer do what the contract requires for any number of reasons, or even if you can technically do what the contract is requiring, that could be very difficult or potentially unsafe. So what we're trying to do in this presentation is to give you a high-level overview of various issues that you might be encountering with your contracts, and that might be affected by COVID-19. Next slide, please. So just a few notes here. The first thing is, we're all New York trained lawyers, so this presentation is going to be focused on contracts that are governed by New York law. Obviously, the United States has a lot of different states, and each state has different types of laws. You might also have contracts that are governed by New Jersey law. For example, we're going to talk about New York law and New York law concepts. These might be similar in other states, but obviously check your contracts to see what state state law governs the contract. The rules might be a little bit different. A lot of these are general principles, but there might be a little bit of difference depending on what state law actually governs your contract. And of course, the other note is there are certain types of contracts that might have special rules. That's employment contracts, residential commercial leases, or real estate contracts, insurance contracts. These may have a lot of different nuances, either in the contract itself, the law, or just practice based on those types of contracts. And there's really detailed questions about those kind of contracts. Typically we recommend actually consulting with a specialized lawyer on those, even though you can go into that conversation hopefully armed with some knowledge about basic contract principles. So this presentation is geared specifically on issues under contracts. There's obviously a whole host of other issues that might be relevant to your small business during this pandemic, such as questions about lawsuits from employees or customers that might be impacted because of COVID-19 interaction with your business, specific questions about regulatory requirements. I'm sure there might be a lot of questions that folks have about the PPP programs and the Small Business Administration loans, and specific things about employment issues. This presentation is really focused on contract issues, though I think there are definitely some researchers will point out at the end that talk about these other topics. Next slide, please. So one thing we'll try to focus on throughout this presentation is we are going to explain some key legal concepts to everyone that relate to contracts so that people know what these are, but that's only part of what is actually going to be important as you're thinking about these issues, right? There's going to be a lot of important practical considerations. We'll go through this actually at the end of the presentation, or after we explain all the legal concepts and explain kind of various examples that might be happening, what practical approaches you can take as you're actually thinking about contracts. So with that in mind, just want to point out, a couple of things. Obviously, if there's a dispute between you and the other side on your contract, and you're thinking about potentially pursuing a lawsuit in order to get some rights and remedies, the first thing we want to point out is obviously lawsuits are really time consuming, can take several years. That is something that probably is going to be too long for many people to get any kind of benefit from pursuing that lawsuit. There might be some cases where you might have a shorter procedure, but it still could take several months. Just given the fact that you very likely have limited or no revenue during this time, you may not have the cash on hand to be able to operate while it takes the lawsuit to, settle. Next point, obviously lawsuits are expensive. If you're hiring a lawyer to help you with a lawsuit, which we assume that's very likely, that lawyer can be very expensive. And even if you don't use a lawyer and, are pursuing a claim in small claims court, for example, there might be a lot of costs that are involved with, gathering all the materials ready to go and get all the documents ready for the lawsuit. And, that might involve things, getting employees to help or going and doing a search of your books and records. So that's something that not just the legal cost, but just the cost of preparing materials could be quite expensive. And then I think on this third point, just being very, very practical, we kind of summarize it as you can't squeeze blood from a stone. So one thing that, as you're thinking about this, is keeping in mind who's on both sides of the contracts, and what the circumstances are. If you have a contract that you can't literally perform, even if you go to a court and win a victory, you're not going to be able to, fix the fact that performance might be impossible. And then if you are able to win a judgment and the other party might be another small business owner that may also not have financial resources, then, even if the court says they may have to pay something, then they may not literally be able to, and they might themselves be in a financial situation that might mean that they may have to file for bankruptcy. So just keeping these principles in mind while we explain the legal concepts. So at the end of the presentation, we'll go into a recap of what kind of practical solutions and practical steps that people can be thinking about as they're approaching their contracts. And one thing we do recommend people think about is, well, what are options that might be available, such as delaying obligations or changing the terms of the contract. So we'll explain these general principles of contracts, but encourage you guys to think about kind of other options. So the next slide, please. I think here we'll turn it over to Namat to go over some contract basics.
Great, thanks, Shirley. So we're just going to cover some basic contract concepts that may be useful as you start to kind of think about your options during this time. Next slide, please. So first, what is a contract? A contract is an agreement between two or more people or entities that creates obligations that are enforceable in court. In order for there to be a valid contract under the law, there must be three main requirements. So there must be an offer by one party that is then accepted by the other party in exchange for what we call consideration. So here we have a simple graphic that illustrates those three requirements. First, we have the offer. One party says to the other, I will pay you $20 for your hat. We have the acceptance. The other party says sold, you can have the hat. And then we have consideration, right? So that is swapping the $20 for the hat. And so there, with those three requirements, we have a valid contract. Next slide, please. So under the law, we have, there's a concept called Statute of Frauds that says that certain types of contracts must be in writing in order to be enforceable. And that's mainly to prevent one party from inventing a fraudulent contract. So here we've listed some of the examples of contracts that must be in writing. First, we have contracts for the sale of real estate interests, contracts to guarantee debt for another person, contracts for the sale of goods over $500, which may be particularly relevant. Fourth, contracts in consideration of marriage, so like prenups, contracts that cannot be completed in less than 1 year. Lease agreements longer than 1 year, which also may be particularly relevant. Assignments of insurance policies, a new promise to pay a debt discharge in bankruptcy, and certain negotiation services related to loans, real property, and business opportunities, which also may be relevant. Next slide, please. The next concept that we'll talk about is breach. So what is a breach? A breach is failing to do something that is required by the contract. So normally a breach occurs when the breaching party must do something and it does not. So generally that would be at the time of delivery or at the time of performance. So here we have an example. Sally agrees to deliver 50 toy cars to Bob on May 1st. On May 1st, Sally delivers 25 toy cars. Sally breached the agreement on May 1st because she delivered fewer cars on the agreed date. So there's also a concept called anticipatory repudiation. So that's where one party tells the other party that they will not perform on the contract in advance of when performance is due. So again, that's called anticipatory repudiation. Here we have an example. Charlie agrees to make and deliver custom pink chairs to Barbie on May 1st, with payment due on May 7th. However, on March 15th, Barbie emails Charlie to tell him that she will not be able to pay him for any of the chairs. Charlie does not need to wait until May 7th to say Barbie has breached the agreement. However, Charlie should try to limit his injury, including by stopping work on the custom chairs. And so that's what we call mitigation. In addition, if one party has a good reason to think the other party will not perform, they may ask that party to confirm whether they'll perform or not. And if that party does not give such reassurance, the inquiring party may treat that party as though they've repudiated the contract. So as an example here to illustrate that concept, Barbie hired Danielle to design and print menus. Danielle issued Barbie an invoice for her design work, which Barbie has not paid. Danielle has agreed to print and deliver the menus to Barbie by May 1st, with payment due on June 1st. Danielle hears from Charlie that Barbie is having money troubles. Danielle tells Barbie she is concerned about Barbie's ability to pay for her design work and the menus. On March 20th, she asked Barbie to pay her past due invoice and to pay for the menus up front. Barbie does not agree to either request. Danielle can treat Barbie's failure to provide assurance as a repudiation. So essentially, Danielle there can treat the fact that Barbie did not agree to those requests as an indication that she's not actually going to perform on the contract. Next slide, please. And so here we have some options for after the breach. So while parties may do everything that they can to avoid breaching a contract, we understand that especially during this time, breaching just may be unavoidable for one party or the other. And so it's important to kind of understand what your options are if you fall on either side of that. And so first we have the options for the non-breaching party. The non-breaching party may stop any performance that's owed to the breaching party. They can wait for performance or to renegotiate the terms if the due date has not yet occurred and the contract is not impossible. They may also resort to any remedies available for breach of contract, lawsuits, and the like. But as Shirley stated earlier, it's important to keep in mind the costs associated with those avenues. However, typically the breaching party must be given a chance to correct the breach. And so normally contracts will have provisions where you have to notify the other party of the breach, and then they may have a certain amount of time where they can cure or correct the breach before any of those remedies might be available. Next, we have the defenses for the allegedly breaching party. So first, that party may allege that there was no breach at all. So performance is not yet due, right? So if they were scheduled to perform on May 30th, they can say that, you know, that time hasn't yet come, so there hasn't been a breach yet, or that the contract has been performed. Secondly, that party may argue that performance here is excused. So that could be for a number of reasons. There may be a contractual provision saying that performance is excused, such as a force majeure provision, which we'll go into in more detail later in the presentation. And then there's also the concepts of impossibility and frustration of purpose, which can also be used to excuse performance. Those concepts will also be touched on later in the presentation. Next slide, please. So now I think Laura is going to walk us through the main types of remedies for breach.
Great, thank you, Naman. This is Laura Doherty, and we're going to talk about the main types of remedies for breach. So as you can see, we separate the main types of remedies for breach into basically 3 baskets. Our first basket are money damages. So money damages are those that are meant to compensate the non-breaching party for the economic harm caused by the breach. So for example, if I had a contract to sell Bob a basket of peaches for $20, and then Bob breached the contract and I could only sell it to Sally for $15, my economic harm would be $5. Those would be money damages. As you can see from that example, money damages are not intended to be a penalty. The idea is that they compensate you for the harm that you suffered. Within money damages, there are 2 concepts of types of money damages. There are direct damages, which are those that result directly from the breach. So for example, in our example about the peaches, that would be the $5. These are the damages coming directly from the act of the other party, as well as indirect damages that are sufficiently connected to the breach. So indirect damages may refer to things that go beyond directly what was promised within the contract into the implications of the fact that the other party breached. Maybe they could include lost profits or personnel costs or things like that, but they can be significantly more difficult to recover. The next basket that we have is specific performance. So specific performance means that the other party has to do what it said it was going to do in the first place. So for example, if I hired Jose to paint a mural, the court could order that Jose has to paint the mural. That would be specific performance. However, specific performance is usually difficult to obtain because courts tend to favor awarding money damages, as it's a lot cleaner than saying that someone has to do something specific. The final basket that we have are damages for the sale of goods. So we'll talk about this a little more, but sale of goods tends to have unique rules under something called the Uniform Commercial Code. So in the case of the sale of goods, if there is a breach by the seller, the buyer can cancel the contract, recover the goods, or seek specific performance. If there is a breach by the buyer, the seller can withhold the goods if they have not yet been delivered, recover the goods if they have been delivered, or in some situations, force the buyer to accept the goods. So let's look at an example. Oh, sorry, next slide, please. Perfect, thank you. So let's look at an example about some of the different types of money damages. Within the concept of money damages, there are different options. So here we have a hypothetical situation. In September, a homeowner hired a contractor to build a new house for $100,000. The contractor expects they'll profit $20,000. The contractor goes and buys $10,000 worth of materials and uses these materials to put in a foundation for the home. However, the homeowner refuses to pay the contractor. So the contractor sues the homeowner for damages. If there is a lawsuit and a court rules in favor of the contractor, what amount of damages will the contractor receive from the homeowner? There are 3 different types of damages that the contractor could recover. However, to be clear, these are 3 different options. Recovering more than one of these would be considered to be a double recovery, as they're all intended to remedy the harm that the non-breaching party has suffered. So our first set is called expectation damages. Expectation damages are those that are meant to put the other party in the position they would have been in had the breach not occurred. So here the expectation damages would be $20,000, which was the expected profit for the contractor. The second type are called reliance damages. Reliance damages are intended to put the injured party in the position they would have been in had the contract never been made. So here, the homeowner would owe the contractor $10,000, which was the amount of money that the contractor had already spent on the materials for the foundation. The final type of money damages are called restitution damages. And the idea here is to ensure that the breaching party basically doesn't get an unfairly good deal because of the fact that they breached the contract. So here, that amount of money would be the value of the foundation that the contractor had already installed for the homeowner. So, however, keep in mind that these types of damages need to be proved in court before they can be recovered. And it can be particularly difficult to recover damages in the event that they're not certain. In our hypothetical, it was pretty clear what they would be, but the real world can be a little more murky. Next slide, please. All right. So beyond that, you can have certain provisions within your contract that might limit the damages that you can receive. For example, parties can limit damages by excluding certain kinds of damages or imposing additional requirements in their contract for the parties to minimize, or we call it mitigate, the damages. One common provision of this type is to see language excluding indirect damages, which are the damages we talked about for things like lost profits, personnel costs, cost to hire a new supplier, and the like. And this is a typical type of damages to be excluded. Another common contractual provision related to damages is something called liquidated damages. So this is a special provision where the parties have agreed in their contract that damages for breach will be calculated in a specific predetermined way or set at a specific amount so that a court does not have to determine the amount of damages to award. So if challenged in a lawsuit, liquidated damages provisions will generally be upheld if the specified amount is, first of all, proportional to the likely loss, like we talked about, monetary damages are not intended to be a penalty, and second of all, the amount of actual loss is impossible or difficult to calculate. To give a quick example, if Mindy had a contract with a factory to produce her secret recipe soaps, their contract might have a liquidated damages provision in the event that the factory leaked her secret recipe to someone else, because the damages that Mindy might suffer could be really hard to quantify because she's unlikely to know exactly which sales she lost because she had to compete with her recipe being otherwise available to someone else. So courts will not enforce liquidated damages provisions if the amount fixed is clearly disproportionate to the probable loss, like we talked about, can't be a penalty, and if it looks like it's meant to punish the breaching party. And I believe Martha is going to discuss some contract issues, particularly related to non-performance and COVID-19.
Thank you very much. So now we're going to turn and we're going to talk about some issues that really have come to the fore in this current crisis, where because of circumstances outside of most people's control, right? The COVID-19 pandemic and the societal and governmental response that has required large segments of the economy to either stay at home or shut down. How does the law of contract deal with a sort of external unforeseeable event like the COVID-19 pandemic when it really prevents somebody from doing what the contract says, i.e. performing under the contract? Next slide. So you may have heard the term force majeure previously. Force majeure is a fancy French word that just means superior force. And broadly speaking, when people in the US talk about force majeure, they're talking about a specific clause that might be in your contract. So it's important to realize that not all contracts include this kind of a clause. But if the contract does, what these clauses say is that if a certain event that is outside of the control of the parties happens, then certain obligations that are required in the contract may be postponed or excused. So that would mean that if it's excused, by a force majeure clause, the party that can't do the thing they were supposed to do under the contract doesn't have to do it anymore, and they don't have to pay damages for their failure to do that. In the past, people often included these kinds of clauses without thinking too much about them, but they've really been something that people have been paying a lot more attention to since the coronavirus pandemic started. And frankly, people weren't thinking about them too much because they deal with sort of big unexpected events, and it's very hard for people to focus on what they can't predict. But now we see what happens when something that nobody expected intervenes. So if you have a force majeure clause in your contract, you're going to want to look at some of these key questions. So the first thing is, does the contract define force majeure? And this might be defined specifically in the relevant clause. If your contract has a big, long definition section, it may be defined in the definition section. And you want to see if it does define force majeure, how is force majeure defined? Is it defined in a way that could be read to apply to the coronavirus pandemic? We're going to talk more in a few slides about those kinds of descriptions that are sometimes used that cover or might be arguably covering the COVID pandemic. Now, the next thing you want to figure out is, assuming that force majeure defines COVID as a force majeure event, then what does the contract say happens to the contractual obligations? Does it specifically say that some but not all obligations are excused? And is there any limit on which of the parties can invoke the force majeure provision to avoid having to perform and avoid having to pay damages for their failure to perform? Does the contract specify what the effect of the force majeure event would have to be before the obligation is suspended or excused? So, for example, does the coronavirus have to make the performance absolutely impossible or only more difficult or inadvisable? So here, to sort of just draw the distinction, excuse me, you might have a contract where you have agreed, leaving outside the actual pandemic environment that we're facing, you may have agreed to rent out a theater so that you can put on a performance. However, before the day of the concert, the theater burns down. It is impossible for you to have that concert in that theater because the theater no longer exists. By contrast, you could imagine a situation where you agreed that you were going to take and deliver something across a bridge. And if you deliver it across the bridge, it's going to take 30 minutes. Now, there's been an accident, the bridge has collapsed, and now you have to go around the bridge. And now instead of it being a 30-minute delivery, it's going to take you a week to deliver it. That's more difficult, but it's not impossible because you can still get around the bridge. So the way that a force majeure provision is written may impact whether something that's really become more difficult is excused, or only things that have become physically impossible are excused. And then you also want to make sure that you cover your bases and understand whether there's anything that the contract requires you to do or requires the other side to do before the party invoking force majeure can do so. So for example, force majeure clauses sometimes require that if a person is saying, look, I can't do the thing that I said I was going to do, and it's not my fault, I shouldn't have to pay you, I shouldn't have to do the thing or pay damages, they have to notify the other side that they're doing it. So you want to make sure that you understand what your obligations or the other side's obligations are with respect to providing notice if a force majeure event does occur that prevents performance in a way that is excused by the clause. Could I get the next slide, please? So here is a sample force majeure clause, and I'm not going to read it out loud. This is kind of a very boilerplate one, and you'll see that there are some terms that have been highlighted in different colors. So the first term that's highlighted is no party. And the reason that I've highlighted that is because I wanted to underscore that this is a clause that allows either party to the contract to invoke force majeure. So neither party to the contract under this clause as it's written would be liable or responsible to the other party if they didn't do what they had to do if there was a force majeure event. The next thing I've highlighted is the yellow text, which reads, except for any obligations to make payments to the other party hereunder. So we don't know what this contract is about, but here is a clear example of something that would not be excused if there was a force majeure event. So let's say there's a force majeure event and this contract is, I have to deliver goods and I deliver the goods before the force majeure event happens that would prevent me from delivering the goods. The other side wouldn't be able to excuse their payment obligation. So this is carving out something that isn't from the scope of what's covered and excused by force majeure. And then finally, in blue, we have the actual definition of force majeure. And this has a lot of different words that are used to describe, to define force majeure. So there's acts of God, which is an ambiguous term, flood, fire, earthquake, epidemic or explosion, war, invasion. And here, so you see it's really just a whole laundry list. So this could be difficult to make it longer, but it could be shorter. You could see a force majeure clause that simply says flood, fire, or earthquake, or just talks about war, or just talks about acts of God. And in particular, we've underscored in green certain words that really are the ones that are most likely to be arguable, relate to the current pandemic situation. So epidemic, government order or law, where there are government imposed shutdowns, action by any governmental authority for the same reason, national or regional emergency, because right now there's a declaration of national and regional emergencies. Labor stoppages is a little bit arguable, because you could argue that really what they're talking about is sort of a strike, but you could argue it. And then the last thing that we have is similar events beyond reasonable control of the impacted party. And what similar events means is going to really be dependent on what was listed before. Sorry, could you go back? Okay, never mind. So here again, we have just a list of, for your reference, the kinds of circumstances that we often see in sorry, could I go to the next slide? Okay, so again, here we've just sort of put separately for your reference when you're looking at these, the kinds of words that are often used in force majeure clauses that you could argue look, particularly describe this pandemic. You want to, of course, read your clause, because your clause may have different words and they may still describe the pandemic. And you also want to make sure that these events are not specifically excluded as a force majeure event. So you could envision a clause, right, which says national or regional emergency is force majeure, except pandemics, right? I don't know that any contracts like that exist, but you could see it. So you want to make sure that you understand if there's anything that's carved out from the definition of force majeure. And normally the specific is controls over the general. So if you had a general description of things that were force majeure that you could kind of argue covered coronavirus, but then you have something very, very specific like pandemic excluded, that would weaken the argument that COVID-19 is covered. Can we go to the next slide? And so here are some basics of New York law on how to sort of read these clauses. So New York courts tend to interpret force majeure clauses pretty narrowly. They sort of assume that the parties, when they entered into the contract, wanted the contract to be performed. And so they will excuse non-performance based on force majeure only if the clause specifically includes an event that actually prevents a performance, okay? And if there's a generic catch-all provision, so like among others or other similar events, courts will generally limit those to include only events of the same kind as the examples that are listed beforehand. So for example, a list of poodles, golden retrievers, chihuahuas, etc., where that etc. is that catch-all phrase, the etc. would encompass Dalmatians and other dogs because all of the items before are dogs, but not cats, right? So if you see a force majeure clause that describes only natural disasters, it wouldn't include pandemics or war. And another thing is, courts will usually require that an event has been unforeseeable so that the exact timing may matter. If you entered into a contract in January, it's very different than a contract that you entered in April in terms of how foreseeable the force majeure clause, the force majeure event was. Next slide, please. Even if there's no force majeure clause or the force majeure clause doesn't apply, there's sort of these two general rules, impossibility and frustration. They're kind of hard to apply, but the general idea, like they apply quite narrowly, but the general idea is if there's something that was completely unanticipated by the parties and it really makes it impossible for the parties to, like really completely impossible for the parties to do what they expected to do, then that will be excused. Frustration is a little trickier because normally there's some unforeseeable event that really couldn't have been anticipated, really couldn't have been prevented. And it just makes the whole contract valueless to the affected party. So for example, if a bride hired a caterer to cater 500 persons to a wedding, but the wedding was canceled, maybe it's still possible for her to pay for those 500, those 500 place settings, but there's no point to the contract, and everyone understood that that was the point. So the contract would be frustrated, and that could, under the law, excuse the bride from paying the caterer for the 500-person wedding. But again, these are difficult to apply, so you should keep them in mind as negotiation points, but know that they're difficult to apply. Next slide, please. Now, outside of these sort of excuse doctrines that we've been discussing, force majeure, impossibility, and frustration of purpose, there are a couple of other avenues that parties might consider if they're dealing with a contract. One of them is an amendment. So what amendment is when the parties agree, they can add, delete, or correct part of the contract without completely replacing the contract. And this is helpful to keep in mind if you want to postpone or reschedule an event due to the outbreak of coronavirus instead of canceling. And so in order to understand how to go about amending the contract, you should see if your contract has a provision that allows for amendments or modifications, and make sure you understand what's required to amend and whether there are any notice requirements. Quite frequently, contracts will include a clause that says that you cannot make any oral changes to the contract. So you should make your changes in writing anyway, but it's particularly important to do so when there's a no oral modification clause in the contract. And then the other thing is termination, which allows you to sort of end the contract. And so depending on the circumstances, and maybe that you or the other party wants to cancel the contract, and that depends on whether you or the other side wants to just undo the whole contract and are comfortable with giving up all of the benefits and sometimes paying a cancellation fee. So if a contract is no longer working for you, you should look and see if there is a cancellation or termination clause, which will tell you whether canceling the contract is an option. It'll explain the process, or it should explain the process that you need to follow the cancellation and any notice requirements. There may be a cancellation fee, which may or may not, be enforceable if it operates as a penalty. And you should be aware that not all contracts provide explicit cancellation options. Next slide, please. So dispute resolution is something that you want to think about as a last resort. So a lot of contracts will have what are called dispute resolution provisions, which basically tell you if the parties really can't agree and you have to go and get somebody else to make the decision for you, like a court, what do you have to do before you do that? And how do you have to do that? So if you're really not making any progress in terms of negotiating with the other side, and you think that you may be headed towards a lawsuit of some sort, you need to check to make sure that whether there's a provision that requires that you take any action before you sue. Some contracts will require you to negotiate with the other side before you start a lawsuit. They may require that you do that for some amount of time. There may be some requirements regarding specific notice requirements. So you want to make sure you understand whether you're required to formally notify the other party of the dispute, and if there are any specific requirements for how you do so in writing, via FedEx. Is there a specific person that you have to direct this to? And is there any time amount that you have to wait? Sometimes you have to tell someone, there's a dispute, and then before you can take the next step, they have to have 30 days to respond. And you want to make sure that you understand whether your contract mentions something called arbitration or something called mediation. And arbitration is an alternative to a traditional lawsuit where you go to court. In an arbitration, the parties basically hire a independent third party to act as a decision maker. Mediation is similar in that you hire a third party, but they don't make the decision. They just try to help the parties settle their disagreements. And so you want to make sure that the contract doesn't, you want to make sure you understand whether the contract requires you to mediate or arbitrate, because if it does, you may not be able to go to court. You may be forced to mediate or arbitrate instead. And you also want to make sure you understand if the contract does allow you to go to court, whether the contract specifies a specific court or place where the lawsuit may be brought. And if you really are considering taking legal action, or the other side is threatening legal action instead of other options like negotiating, it's important to review these dispute resolution provisions and make sure that you follow them, because as I mentioned before, a court may decide that it can't address your case if you haven't done what you need to do, especially if you've agreed to binding arbitration instead of a traditional lawsuit. And with that, I'm going to turn it back over to Nimat for the next section.
Thanks, Martha. So now we're just going to talk about some practical considerations that you should keep in mind as you kind of go through this process. Next slide, please. So first, there are some certain steps that you'll want to take now to ensure that you preserve any rights that you may have under the agreement. And so first, you'll want to just gather the contracts and assess your obligations. So that means, pulling out the actual contracts themselves, and then trying to just determine if you're going to be able to meet your contractual obligations, and or if you're concerned about whether your counterparty will be able to meet their obligations. Next, you'll want to notify customers and counterparties if you know or think you can't meet your obligations. So here it's really important to note that you should not assume that because everybody knows about COVID-19 that formal notice is not required. Under your contracts, there's usually a notice provision that'll clearly lay out the requirements under the contract for providing notice to the other party and how you should go about doing that. So it's really important that you take a look at that clause and that you make sure that you follow those guidelines. You definitely want to avoid delaying notice if at all possible. Next, you'll want to document all calls, emails, communications with counterparties. And that's even if you usually communicate by phone, which we understand may be common. But at the very minimum, you should try and keep detailed notes of all of those telephone calls. So the date, the time, what you discussed. Also, if you make any modifications to your contracts, that should be in writing. So even if you discuss it, over the phone, it's really important that you have that documented so that in case anything happens moving forward, you have that evidence in writing. Also, it's important to make clear whether any documents that are shared are going to be part of settlement negotiations. You should assume that any documents can end up in front of a judge or a jury. So just be mindful of what you put in writing and how that's done. Next slide, please. So what documents should you review? It's really important that when reviewing your contract that you collect and review the full set of documents that make up a contract. And so that might include the original contract or lease. You'll want to try and find the signed and dated versions. But it also includes other documents such as any amendments or renewals that have been made. These are really common in leases as well as in government contracts, where you might not have the entire contract redone. You may just have like an extra page or two that amends that original document or renews that original document. Also, you'll want to look at any riders, which are just basically like side documents that are attached again to the original document. These are common in leases as well. Any other kinds of agreements or documents that are referenced in that main contract, such as requests for proposals or proposals in government contracts or master leases, any subcontracts or subleases, any schedules, annexes, exhibits. So basically, you want to review the whole world of information there and not just the original contract itself. You want to make sure that you read the whole contract, including all of those documents we kind of went through above, paying special attention to any defined terms in the agreements, as well as how the different parts of the contract interact with one another, as it's typical for different sections of the contract to reference one another. As you're reviewing that full set of information, there are some clauses that are particularly relevant. So any clauses around termination rights, how and when that you can terminate the contract, clauses around cancellation rights, again, how and when you can cancel the contract. Any clauses that deal with changes, amendments, modifications, how that must be done. And again, an emphasis on putting any of those in writing. Material adverse change, no oral agreement or oral modification. So if it clearly says that in the contract, then you'll want to make sure that any modifications are in writing, which is good practice anyway. Force majeure clauses, sometimes referred to as act of God clauses, excused non-performance clauses, any insurance requirements, notice requirements, which I touched on previously, making sure that you pay attention to exactly how and when notice has to be given so that you don't forfeit any of your rights just by virtue of the fact that you didn't give notice to the other party the way that it was outlined under the contract. Any limitations on damages, which Laura touched on earlier in the presentation, indemnity clauses, and any clauses around repudiation. Next slide, please.
All right, hi, this is Laura. So the next kind of piece of advice we have for you is that we recommend that you focus on the possible and the practical. So as we've discussed before, bringing a lawsuit can be quite expensive and slow. So it's not likely to be practical in many situations. So instead, we recommend that you do what we often do, which is to do your best to discuss and negotiate with your counterparties to see if you can reach an agreement that works for everyone and see if you can resolve the issue in that way. In the circumstance that renegotiating, modifying, or amending your contract isn't possible, then that's a great time to try to think creatively about things that you can do to mitigate potential damages so that you may not have as much of an obligation, monetary obligation to the other side, or otherwise mitigate the impact of the disruption. So we've included on the left half of this slide some key questions to prepare for negotiations. And we think that it's really helpful to take the time to really go through each of these questions before you go to renegotiate a contract, and really sit down and write out your answers so you're all set to go. So of course, what is your goal? What roadblocks do you think there may be? What's really essential to you here? Basically, the focus here should be trying to decide at what point is it better for you to get no deal at all than to get some sort of compromise. Obviously, it may not be what you want, but just kind of keep that in mind. Also think about, what does the other side need? Maybe you can come up with a creative solution. Think about what your leverage is, even if you know that it would be quite difficult to bring a lawsuit. If you think you have a strong legal argument, that could be good leverage for you in the negotiation. You can also use as leverage things such as that you may, I certainly hope not, but may go bankrupt, that you may, this might destroy the business relationship if they don't renegotiate with you, and things like that. Also, you want to think about what the other side's leverage might be so that you're ready to address those points. And again, I think the number one point to emphasize is think about any potential creative compromises or solutions there may be to solve the problem for everyone. An example we give would be postponing payments. Next slide, please. So we also just wanted to highlight that relationship considerations are very important in preparing for negotiations, as at the end of the day, disputes don't exist in a vacuum. So when you're preparing for negotiations, it's important to think about how important to you is this business relationship. Is it important to your business that you maintain goodwill with this person, or is it a viable option to just walk away? For example, you might want to consider how easy it would be to get a replacement contract if you needed to. You can also think about the situation the other side is in. Are you a key supplier for them? If so, you may have some more leverage there. Another thing to think about is whether or not the other side is likely to be fair and reasonable if you are. While of course you best understand the unique situation and you've worked with these people before, we often find that people are more amenable to compromise if they feel that everyone involved is being fair and reasonable. And of course, as I'm sure you're all very aware, this is a very stressful time for everyone. And when you're negotiating business contracts, we really recommend to try to avoid taking it personally and try to avoid making it personal, as at the end of the day, if everyone feels like this is fair, reasonable, and focused on the business, you're more likely to be able to come to a good business agreement. And so the final piece here is, again, just some ideas for how to plan your negotiation strategy, like the list of questions that we included on the previous slide. You know, to the extent that you think about answers to these, it's worth writing them down. So as Nimat said, review your contracts, review prior communications, make sure that you really understand what the contracts say and what you've agreed to. Figure out your leverage and the counterparty's leverage in the negotiations, and think about how COVID-19 may have impacted the contract itself. Think about what your opening negotiation position will be. Where will you start? What's kind of your strongest position? What's your ideal world? But also think about kind of where the end of the road for you is, kind of the last thing you would accept if you needed to, rather than just getting no deal. Consider any possible responses you may have to things that you think the other side might say. And then finally, consider that you may not be able to solve everything in one sitting. There may be things you have to go back and think about, and think about kind of good ways that you could wrap up a conversation and save it for another day. So I think, you know, as you're getting ready to maybe renegotiate some of these contracts, you'll all get a copy of these slides, and we really recommend that you take a closer look at some of these preparation points. And with that, I believe Shirley is going to speak to us about some other things to consider.
Yes. So just as a final capper, just wanted to point out a few other points for folks to consider. So we've explained a lot about contracts, negotiation, and amendments, but here's some other things we wanted to flag. So first point is on insurance. So even if you're not able to, for example, claim that there was a force majeure event, you may still be able to get some kind of coverage from your insurance policies to get some kind of recovery due to the impacts of COVID. So obviously for that, look at your policies. You'll probably have to call your broker to walk through those, but that might be a potential option. Next point is on new contracts. So we're talking about existing contracts that you might have issues under and that weren't anticipated because of COVID. As you're entering into new contracts or adjusted contracts post-COVID, just think about if any of the things we talked about might be helpful to consider as you're looking at that contract. I think in particular, you know, you're not going to be able to say that force majeure includes the pandemic, for example, necessarily, but think about, well, what kind of flexibility might I have in cancellation, termination? You know, these are things that I think folks know might actually happen. If you're trying to book an event space for, you know, the fall, maybe think about, is there a termination clause? What cases can I terminate? Is there something in there I want to adjust in a new contract? And try to avoid, you know, similar issues like what you're facing now. And then the last part is just keeping track of news and updates. You know, things are constantly changing. There's a lot of new regulations and policies because of COVID-19. There's a lot of governmental, state, federal actions because of this, a lot of new programs. So just keep on following the news and, you know, various websites for recent updates. And, you know, some of these might override what's in your contract. You know, for example, there was an executive order that says that landlords can't evict people, even if they're not paying rent up to certain dates and things like that. So it's not just the contract, but also what other rules and regulations have come out that might override that. And those can change day to day, week to week, month to month. So next slide, please. So we'll just go over a few additional resources and then have Akira wrap it up. Next slide. So here are just a few, these will be links on the materials to other resources that we found helpful. And I think with that, I'll turn it back over to Akira.
Thank you all so much. I want to thank everyone for joining us today on this webinar. Thank you to our speakers, Shirley Lowe, Martha Vega Gonzalez, Namat Lawal, and Laura Doherty. and also to Catherine Hughes for addressing questions in real time throughout the presentation. Thank you again to Cleary Gottlieb for partnering with us on this presentation and for assisting small businesses during this time of crisis overall. And also thank you to the Brooklyn Small Business Development Center for co-sponsoring this event with us today. For those interested in more information on our COVID-19 remote small business legal clinic or who want to request a consultation, please go to our website at www.citybarjusticecenter.org. You'll also be able to access that information through the presentation. And also, next slide, please. Please see the contact information for America's SBDC or our friends at the Brooklyn Small Business Development Center, who again have been a wonderful resource to small businesses throughout this process as well. And with that, in closing, just a reminder, everyone will receive a copy of the slides and the recording after the presentation. And again, thank you for joining us today. Be well all.